Pedro Vasquez Perdomo. How many millions of Pedro Vasquez Perdomos does America really need? Anybody know? I'm thinking the figure is something under 100 million, which is what we currently have. Order granting plaintiffs ex parte application for a temporary restraining order. And then she wants to follow that up with a preliminary injunction. Ex parte. She only heard from the illegal migrant third world invader faction. The federal government was not present to argue against her decision. She writes, Judge Frimpong, on June 6, 2025, federal law enforcement arrived in LA to participate in what they've described as the largest mass deportation in history. The individuals and organizations who have brought this lawsuit argued this operation has two key features which are unconstitutional. Roving patrols indiscriminately rounding up numerous individuals without reasonable suspicion, and having done so, denying these individuals access to lawyers who could help them navigate the legal process they found themselves in. They found themselves in this process, folks. They didn't put themselves in this process. You know how you not get detained by ICE? I know this is going to shock all of you. You don't get detained by ICE simply by the simple expedient of not being an illegal migrant third world invader. Stay in Guatemala, stay in Mexico, stay in Venezuela, stay in Haiti, stay in Ghana, Judge Frimpong. ICE has no interest in you if you're not an illegal migrant third world invaders. On this, the judge writes, the federal government agrees. Roving patrols without reasonable suspicion violate the Fourth Amendment, and denying access to lawyers violates the Fifth Amendment. What the federal government would have this court believe, in the face of a mountain of evidence, is that none of this is actually happening. Right. None of this is actually happening. Because roving patrols are operating with reasonable suspicion. So they don't violate the Fourth Amendment, and people are not being unlawfully denied access to lawyers. They're entitled to their own lawyers. That doesn't mean the government has to let any lawyer walk into any detention center and talk to every detained illegal migrant third world invader. Any more than a criminal defense attorney can walk into any jail and just talk to every person detained in the jail. That's not how this works. Of course, this judge has only been a judge for 3 years. 3 years. Most of the questions before this court are fairly simple and non-controversial. By the way, when she says the mountain of evidence, remember, this was an ex parte hearing. The government was not present to contest any evidence. The only evidence presented was presented from the pro-illegal migrant third world invader side of the argument. And we all know if you ever hear only one side of an argument, of course it sounds compelling. Mountain of evidence. Even though this judge also has to say later in this order that, hey, listen, it's just a TRO. I'm not saying any of this evidence is true, but she's using it to issue this TRO against the Article 2 executive branch president of the United States, elected by the whole of the American people to carry out our will. The questions before this court are fairly simple and non-controversial. May the federal government conduct immigration enforcement? Yes. Do all individuals share in the rights guaranteed by the Fourth and Fifth Amendments? Sure. Is it illegal to conduct roving patrols which identify people based on race alone? The government, of course, denies they're doing this. This, of course, would be unconstitutional. If an ICE officer had a dentist appointment and he walked into the dentist appointment and sitting in the waiting room already there was someone who appears to be Hispanic, could the ICE officer simply detain that person and aggressively question them? No. But if that person is amongst a group of idle men standing in a Home Depot parking lot known to be a pickup area for day labor, of illegal migrant third world invaders. That's not unlawful profiling based only on race. That's profiling based on the totality of the circumstances beyond just race, which is, of course, completely lawful. And if it's not being done upon race alone, and it's not, then they can detain them without a warrant, without their consent, and without reasonable suspicion that they are without status. They can detain them to investigate status. So by putting this upon race alone, she poisons the question. Is it unlawful to prevent people from having access to lawyers who can help them in immigration court? Yes, it is. Well, no one's denying them access, but that's a different question. Does every NGO lawyer have a legal right to talk to every illegal migrant third world invader who's detained someplace? The answer to that is no. There are really two questions in controversy this court must decide today. First, are the individuals and organizations who brought this lawsuit likely to succeed in proving that the government is indeed conducting roving patrols without reasonable suspicion and denying access to lawyers? This court decides based on all the evidence presented. Remember, the only evidence presented is by the individuals and organizations who brought this lawsuit. And second, what should be done about it? The individuals and organizations who have brought this lawsuit have made a fairly modest request that this court order the federal government to stop. Stop what? Stop enforcement of national immigration law. Before the court are two ex parte applications for temporary restraining order and preliminary injunction, and the court grants those orders. Madness. All right, I'm going to skip over the factual background of Pedro Vasquez Perdomo, Carlos Alexander Osoro, Isaac Villegas Molina. I wonder how many of these people are murderers, rapists, human traffickers, spousal abusers, members of MS-13 terrorist gangs, like our good friend Kilmar Armando, Arbrega Garcia, Maryland man. They were picked up at Home Depots and car washes and all places known to make use of illegal migrant third world day labor. Let's see. This order is not a final decision on the merits of any claim. Well, no temporary restraining order is. Nor is it a decision on the merits of the factual assertions. Remember the mountain of evidence the judge just cited as justification to issue this temporary restraining order issued by an unelected black-robed tyrannical inferior federal district trial court judge against the entirety of the Article II executive branch president enforcing national immigration law. That mountain of evidence. Well, the judge is not making a decision on the merits of the factual assertions either party made in support of any claim. It was ex parte. There was only one party making claims. Very few circumstances justify the issuance of an ex parte TRO solely for extraordinary relief and rarely justified. Do these ex parte TROs being used against the Article II executive branch seem extraordinary and rare to you, folks? They certainly don't to me. Defendants argue plaintiffs cannot establish they are entitled to seek this TRO on an ex parte basis because they delayed filing by over a month, and they elected not to file a new case, but instead joined a largely mooted small habeas petition. Defendants further argue plaintiffs have not satisfied the mission power standard. The court finds the plaintiffs acted expeditiously in this case. It's undisputed the events started in early June, and the plaintiffs filed the first 1AC on July 2nd. Defendants contend this month-long delay should be construed against plaintiffs, but provide no authority, holding that a month is an unacceptable time period, so it's in the discretion of the judge. It doesn't matter. All this is boilerplate of the judge just saying, I already know how I want to rule. I want to grant this ex parte TRO against ICE, so I'm just going to make up word salad to make that happen. The access detention plaintiffs assert that they have standing because defendants have impeded their ability to engage in the representation of immigrants and refugees that is the core of their founding mission. This is the founding mission of the pro-illegal migrant third world invader NGOs. And of course, the court is sympathetic to the founding mission of these pro-illegal migrant third world invader NGOs. I'm going to skip all the boilerplate too. Just get to the major holdings here. They've established they're likely to succeed on the merits. It's all nonsense. That they'll suffer irreparable harm. The harm all these illegal migrant third world invaders are facing is, guess what, folks? Guess what the harm is that they're facing? Going home. It's not a harm or punishment for you to be denied something you have no right to. These people have no right to be in our nation. It's not an irreparable harm for them to be sent home. It's like they talk about Alligator Alley like it's some kind of concentration camp. It's the weird concentration camp that processes people in 3 days to go home. If only the concentration camps in World War II Germany had been run that way. Nobody would have any objection. This court has jurisdiction. Defendants contend this court lacks jurisdiction under immigration law and also assert that 8 U.S.C. 1252 bars this court from considering plaintiffs' claims. They raise these arguments. The court will address this issue first, as jurisdiction is a threshold matter. The Immigration Nationality Act sets forth jurisdictional limits in Section 1252, entitled Judicial Review of Orders for Removal. Let's see. This court rejects defense arguments. The key authority with respect to this is Jennings versus Rodriguez and some other cases. The binding authority dictates that treating everything related to and leading to removal proceedings as arising from a removal action is an incorrect reading of the relevant statutes. The court just wants jurisdiction, so she's going to pretend that she has it. Defendants argue the TRO is overbroad and insufficiently specific. The court, of course, finds its own TRO is sufficiently specific in light of the conduct at issue. Here, the stop arrest plaintiffs largely seek to enjoin defendants from conducting detentive stops without the legally required reasonable suspicion and from solely relying on 4 enumerated factors alone or in combination. Well, if they're prohibited factors, ICE was already not doing that. They're not making detentions based just on race or skin color. That's ridiculous. They're going to where they know illegal migrants to be. This is not secret knowledge. Of course, she finds they have standing. Preliminary injunction is available even in the absence of a class certification. Defendants briefly argue that absent class certification, plaintiffs cannot seek the TRO because of the recent Supreme Court decision. To be clear, to provide complete relief to the named stop arrest plaintiffs, even without considering the unnamed class members and the propriety of class certification, this court must enjoin the conduct of all law enforcement engaged in immigration enforcement throughout the federal court district. Particularly given how these enforcement actions appear to have been conducted, it would be a fantasy to expect that law enforcement could and would inquire whether a given individual was among the named plaintiffs or the putative class before proceeding with a seizure under the Fourth Amendment. Of course, she says they're likely to succeed on the merits. More nonsense. 52 pages of this nonsense. She talks about the 4 factors that are unlawful for a stop. The ICE is already not doing that. This is nonsense. Won't survive review. Irreparable harm. We already talked about that. Balance of hardships. Conclusion. For the foregoing reasons, the court orders, capital letters. I thought this was a tentative order. Shouldn't it say for the foregoing reasons, the court tentatively orders to the access detention plaintiffs. These are the ones that want infinite NGO lawyers. I notice she doesn't list defendants as Trump here. This is another lie that these judges, these unelected black-robed tyrannical inferior district trial court judges, bake into their orders. They pretend that if they don't name President Trump, they're not actually enjoining the Article 2 executive branch of government under the Constitution. But obviously, if you enjoin every subordinate officer of Trump, Trump isn't out on the streets detaining illegals. He delegates that function to his subordinate cabinet members and other senior officers in the executive branch. If you enjoin all of them, you may as well have cut Trump's arms off. Of course you're enjoining him. Defendants Kristi Noem, Todd Lyons, Ernesto Santa Cruz shall provide access to room B18 of the federal building located at 300 North Angeles Street, Los Angeles. How much more micromanaging can you get? For legal visitation by current and prospective attorneys, legal representatives, and legal assistants, so not just lawyers. What the F is a non-attorney legal representative? I'll tell you what that is. That's a illegal migrant, third world invader, NGO activist. That's what a non-attorney legal representative is. If it wasn't something different than an attorney, we wouldn't have it as a separate listed item here. Enumerated category of persons. A legal representative. My ass. Legal visitation shall be permitted 7 days a week for a minimum of 8 hours a day on business days, 4 hours a day, and weekends and holidays. Let's see. Defendants Kristi Noem and other officers shall provide individuals there with access to confidential telephone calls at no charge. The balance of the equities overwhelmingly favored Churla. Look, folks, it's Churla again. No surprise. No security shall be required under Federal Rule of Civil Procedure 65C. This is the rule of civil procedure that's supposed to require. The rule itself is non-discretionary. It says the courts shall require a security, a bond from parties seeking an injunction. And these judges just wave their hands and pretend that whether or not that bond is required, that security is required, is up to their discretion. There's nothing in the bond requirement of Rule 65C that says it is discretionary. Defendants Kristi Noem and these others are ordered to show cause why this TRO should not convert. Oh, wait a minute. Why they should not be enjoined from further violations of the Fifth Amendment of the U.S. Constitution. This is grotesque in this order. This is saying, Kristi Noem, I need you to come to court and show cause why you're not allowed to violate the Constitution. It presumes the violation in a TRO, ex parte TRO. The stop arrest plaintiffs, ex parte TRO, is also granted. ICE cannot conduct attentive stops unless the agent has reasonable suspicion. Well, of course, that's always been the case. Reasonable suspicion has always been the standard. Defendants may not rely solely on the factors below: race, speaking Spanish or English with an accent, presence at a particular location. This is going to be thrown out. Bus stop, car wash, tow yard, day laborer, pickup site. In other words, you can't go to places where the illegal migrants are found or the type of work one does. These are not constitutionally protected classes. This one is. This first one is. These others are just fabrications by the court. Again, no security shall be required under 65C. And Kristi Noem has to show cause why this TRO should not be, this tentative TRO, maybe it'll be converted into a tentative preliminary injunction. Signed, Maame Ewusi-Mensah Frimpong, United States District Court judge for the last 3 years appointed by Biden. Maybe not even an American citizen, maybe not lawfully present in the U.S. at all. Thanks for watching this highlight segment of our full-length Law Self-Defense live stream. If you enjoyed this content, make sure to give us a like and subscribe for more expert analysis on politics, law, and how to be hard to convict. And to watch the full-length episode of this show, just click right here. Stay safe.